All right, welcome everyone. Now, if you're a student of law, you know that Indian constitutional law isn't just a static subject you read in a book. It's a living, breathing conversation that's happening right now. So today, we're going to map out the key battlegrounds, the landmark decisions, and the big ideas that are shaping India's legal landscape as we speak.
Here's our game plan. We're going to start by looking at the Constitution as a living document. Then we'll dive into how fundamental rights are expanding, the deep complexities of equality, the constant push and pull of federalism, and finally, how the judiciary keeps executive power in check.
So our starting point is this absolutely fundamental idea. The Constitution of India is not some dusty artifact frozen in 1950. It's a living document. It's designed to breathe, to adapt, and to meet the societal, technological, and political challenges of every new generation.
And this metaphor of a living tree is really the key to unlocking everything else we're going to talk about. Think about it. The judiciary's role as the interpreter is what nourishes those roots. It allows timeless principles to apply to things the framers could never have dreamed of, from the complexities of our digital lives to the urgent crisis of climate change.
And you can see this playing out in the headlines all the time. For instance, the recent legal debates are on the new Data Protection Act, or the Supreme Court's huge judgment on the electoral bonds scheme. These aren't just abstract legal issues. They are real-time stress tests of our fundamental rights to privacy and to information.
Now, if you want a perfect example of this adaptive constitution in action, look no further than Article 21. It's so simple on the surface. No person shall be deprived of his life or personal liberty except according to procedure established by law. But from that one single sentence, the judiciary has cultivated this vast, incredible landscape of fundamental rights. Through some really creative and purpose-driven interpretation, the courts have essentially said that life means more than just breathing. It means a life with dignity. So they've read into it a whole spectrum of rights. The right to privacy in the digital age, the right to bodily integrity and dignity, even in death, and just recently, a distinct right against the harmful effects of climate change. It's amazing.
All right, let's switch gears and tackle a really complex and, let's be honest, often contentious ideal: equality. The constitutional conversation has really shifted here. We've moved beyond this simple idea of formal equality, which just means treating everyone the same, to something much deeper: substantive equality, which is all about fixing deep-rooted structural disadvantages.
And this brings us to a central, recurring tension in Indian law, especially when we talk about reservation policies. How do you balance the need to deliver historical justice for entire communities against the principle of individual equality and merit? It's a tough balancing act.
This tension leads us straight to the doctrine of subclassification. So what is it? Well, the core idea is pretty straightforward. Even within large reserved groups like scheduled castes and tribes, there are different levels of disadvantage. So the question is, should the state be allowed to create categories within the categories to make sure that affirmative action actually reaches the weakest of the weak? The Devinder Singh case really puts this whole debate under a microscope. On one side, you have the argument that subclassification is absolutely essential for true, substantive equality. It ensures that the benefits don't just get cornered by a few. But on the other side, there are serious constitutional questions. Do states even have the power to do this? And could it end up fragmenting these communities? This is such a big deal that it's currently pending before a larger bench of the Supreme Court.
And of course, the fight for equality doesn't stop with reservations, not by a long shot. We see it in game-changing judgments like Babita Punia, which took on gender stereotypes in the military. We see it in the Sabarmala case, which introduced this powerful principle of anti-exclusion. And we're seeing courts more and more use the manifest arbitrariness doctrine to just strike down laws that are clearly fundamentally unfair.
Okay, so we've talked about individual rights. Now let's zoom out and look at the very architecture of the Indian state. Federalism here is this delicate and often pretty tense power-sharing deal between the union government in the center and the states. And there is no better or more dramatic case study for this than the long-running legal saga between the government of Delhi and the Union of India. It's a classic example of what experts call asymmetric federalism, where Delhi has this unique constitutional status that's different from other states. And the core of the fight, as you know, has been over who controls the bureaucrats, the administrative services, a battle that has swung back and forth in the Supreme Court for years.
So what happens when these powers overlap and you get a direct conflict? A state law says one thing and a union law says another. Well, that's when a key constitutional tool called the Doctrine of Repugnancy kicks in, thanks to Article 254. It's the tiebreaker, and as a general rule, the union law gets priority. This ensures that there's some level of national consistency when it really matters.
For our final big topic, we're going to look at one of the most crucial roles the judiciary plays, acting as a check on the power of the executive branch. This really gets to the very heart of the separation of powers.
So this is the fundamental question that the courts have to answer over and over again. Can the executive just make laws on its own? Is the power to grant a pardon completely unchecked? To uphold the rule of law, the answer has to be, and has consistently been, a firm no. Let's see how.
So first up, the ordinance-making power. Now, this is a necessary tool, right? The executive needs to be able to legislate when Parliament isn't sitting, especially in an emergency. But, and this is a big but, it's not supposed to be a backdoor to bypass democracy. So the courts have drawn some really clear lines in the sand, especially when it comes to repromulgation, which is just reissuing the same ordinance again and again without ever facing the legislatures.
And this right here shows you just how seriously the judiciary takes this. In the Krishna Kumar Singh case, the Supreme Court didn't mince words. They used this incredibly powerful phrase, a fraud on the Constitution. They said that using the ordinance power to repeatedly sidestep the legislature is a direct attack on the constitutional scheme itself.
It's a similar story with the president's pardoning power under Article 72. You might think this is an absolute, unchecked power, but it's not. The courts won't step in and decide if someone deserves a pardon, but they will review the process. And as cases like Shatrughan Chauhan have shown, a pardon can be legally challenged if it was granted arbitrarily, in bad faith, or based on factors that had nothing to do with the case.
So, after covering all that ground, let's pull it all together. What are the really crucial points you should walk away with from this look at contemporary constitutional challenges? Ultimately, these are the core tensions that define Indian constitutional law today. It's a nonstop dialogue between an old text and a new world. It's a constant balancing act between individual rights and state power, between social justice and formal rules, and between the center and the states.
And that brings us to our final thought, a question for the future. As our society, our technology, and our environment keep changing at a dizzying pace, what's the next great constitutional frontier? What's the next big question that will be tested and reinterpreted? That really is the question that your generation of legal minds will be called upon to answer. Thanks for joining this explainer.